Hi, my name is Michael Kohn. I'm the founding partner of Kohn, and Colapinto, the world's first law firm exclusively dedicated to whistleblowers, and I'm also the co-founder of the National Whistleblower Center. Well, I guess I'm here to tell you the story about how federal whistleblowers were able to get into federal district court. That journey really began in about 2008. And that was a case known as ICOSI versus the Department of Navy. And basically, there was already existing case law that allowed Title VII whistleblowers who were federal employees to bring their Title VII cases into federal district court. And Title VII employees would also have federal rights. And so there was a complex set of rules and regulations that allowed these Title VII claims to get into federal district court, and that had been established. There was a whole separate set of regulations that dealt with whistleblowers, and whistleblowers had been delegated to the Merit Systems Protection Board, which was a failed system. Whistleblowers were essentially just continuously screwed over for decade after decade. And as I started trying to find a path to get my whistleblowers out of the MSPB, I had one of the longest practicing whistleblower attorneys in the nation, and I didn't file my first whistleblower case in the MSPB until like 2008. And that was this case to get it out of the MSPB, okay? So basically, I looked at the regulations and I said, there's no reason a whistleblower case can't be co-joined with the Title VII case and bring both of them into federal district court when it's right to bring one of them in. And National Whistleblower Center would hold seminars and symposiums, and Joe Kaplan, who I'd like to dedicate this lecture to, was on several panels with me over the years. And Joe was a true fighter. He knew more about federal employment law than anyone in the world. He had written the best treatise on it, and him and I would have debates in the seminars, and he would say, no, it's impossible. You can't get federal district court coverage for the whistleblowers. And I said, oh, I think I got it, Joe. And so the first case was just getting the ability to get a Civil Service Reform Act claim in front of federal district court, not a whistleblower case, and just a Civil Service Reform Act case, which meant you were demoted, fired, something bad happened to you in the federal government, and you could get into the Merit Systems Protection Board. But if you also happen to have a Title VII claim, which was race, sex, age, disability, and national origin, if you had one of those 5 claims, you could couple it with your federal employment claim and bring it into federal district court. So I said, I'm just going to couple the whistleblower claims with it. I looked at the rules and regulations. I said, there is no logical basis to distinguish why you can't do it with the whistleblower claim. So I filed this test case, ICOSI versus the Department of Navy. She had been demolished and screwed over by the MSPB. They were just waiting for the final order to be issued and her case would be gone. And I said, well, no, under these rules, 120 days went by. I can now bring her Civil Service Reform Act claims over to federal district court and get rid of the jurisdiction of the MSPB. And that's what I did, and went up to the Court of Appeals, and the Court of Appeals, the DC Circuit agreed and said, yes, you can bring those cases as a mixed case up to federal district court because ICOSI was a woman, Cypriot, so she had national origin and sex discrimination, and believe me, it was rampant where she was. And at And then, Joe and I are having these debates. He said, no, well, that's okay, but you're not going to get the whistleblower portion there. I said, no, I think I got it. And then came Bonds versus NIH. And in that case, this was now a whistleblower, a Black woman, who claimed that in the research projects that they took cell lines from the Black subjects and developed them in the lab and had them growing or ready to be used for scientific experiments without ever getting waivers or permission from the people, from the cell owners or the original people who donated the cells. And she was outraged by that, and she raised it up the ladder and ended up being terminated. So now we had a whistleblower case and a Title VII case, and I brought that up, and district court, said, yeah, we know about this ICOSI case, but I'm not going to follow that and rule against us. And we took it up to the Fourth Circuit, and the Fourth Circuit analyzed it very carefully and said, no, there was no logical basis to deny whistleblowers the ability to join their case as a mixed case, as everyone else does. And once it's joined as a mixed case, and you comply with the regulatory requirements of a mixed case, you can bring it to federal district court. And that basically meant that you had to file your whistleblower case with the EEO office of the federal agency, not with MSPB, just with the EEO office. And you just put in the complaint, I was discriminated against on the basis of, you have to really specify which one, and whatever evidence or proof or whatever you have for that. And then you have to provide a separate paragraph that says, I was also discriminated because I was a whistleblower and blew the whistle on X, Y, and Z, and make sure you meet all the elements of the whistleblower claim. Although those complaints are liberally construed, so they don't have to be the best written things. And once you do that and file it with the EEO office, then the administrative mechanisms start taking place. And they're slow. So 120 days is going to pass before you can bat an eye. And the rules and laws allow that once the 120th day hits and there isn't a final decision from the EEO, then you can then just bring your case into federal district court and go for a jury trial in federal district court. And that's basically it. You have to wait 120 days for your mixed case that you file with the EEO office not to be resolved to a final judgment. And if it happened to be resolved to a final judgment, then you still have the same appeal rights within 30 days after the final judgment. So basically, you're guaranteed to get into federal district court with your mixed case as a whistleblower. So that means, as a result of ICOSI, any whistleblower who's essentially age 40 or over, a woman, a minority, from national origin, or blows a whistle in the workplace on those things, and they're a whistleblower on the class of things that the MSPB has said qualify as whistleblowing, then you get into federal district court. And the real beauty of it is, you really have to fight those Title VII cases. They're not easy to win. The Title VII cases are much harder to win than the whistleblower case, because the standard of proof on the whistleblower case puts essentially the burden on the agency to demonstrate that they have clear and convincing evidence that the action they took was not as a result of the whistleblowing. So in Title VII cases, basically the burden remains on the employee to essentially produce evidence that you were discriminated against. So it's a much better remedy. Well, not remedy. It's a much better standard. The damages are slightly less because you don't get the $200,000 in cap damages under Title VII, but you get reinstatement, you get your attorney's fees, and you get all your back pay. So let's hear it for, and more importantly now under this current administration, there is really no such thing as an MSPB because the board has not been appointed, which means it is impossible to get a federal whistleblower case adjudicated since Trump essentially has been president. And with this mechanism, you can bring your whistleblower cases into federal district court, even though the MSPB isn't functioning. All right. Thank you very much.